Good morning, everyone. Me calling the meeting to order. This is our Policy and Personnel Committee meeting. Today's Tuesday, November 2nd. And to you, Amber, for an attendance.
Thank you, Daryl Duzinski. You're with us. Ava Bermuda Zimmerman. I know you're in the car, but you're with us. Mike Soltis.
Present.
Okay. And Paul Potamianos. I don't think he has joined us yet. But we do have a quorum.
Commission meeting, so I doubt he'll be joining us.
Okay.
Okay.
All right, Daryl.
Excellent. All right. We discussion on the October 5th, 2021 meeting minutes. Going through our last meeting. Any concerns or questions about the meeting minutes?
No.
Motion for an approval?
I move to approve the meeting minutes for the October 5th meeting.
Second.
Thank you. All in favor?
Aye.
Aye.
Aye. Any disagree? Okay, we're all set there. The next is a discussion, comments received in connection with the private plan policies to Aaron and Michael.
Good morning. Thank you, Daryl. Perhaps the easiest thing would be if I could share my screen. Amber, if you can make that possible.
You're all set, Aaron.
As you know, just as background, we posted 3 documents as part of the private plan policies. The private plan policies and procedures document, which updated the policy that was adopted by the board last year, policy filing guidance notice that really detailed what the insured policies will need to contain in order to be approved by the Department of Insurance, and a checklist, which we anticipate, or we're going to require insurance companies to submit when they submit their policy forms to the Department of Insurance. So they're all interrelated, and in fact, the checklist really just mimics the information that's in the other documents, but in a more condensed format. We received comments from a number of different sources, including the Insurance Association of Connecticut, some advocate groups, some other state agencies, and sort of interested people. Not all of them were necessarily formal, but we tried to include them all. But we didn't if certain people said the same thing twice, we didn't list it twice on the checklist. So the document I'm sharing with you is sort of the summary of the comments that we received with our recommendations as to whether we anticipate that the comments should justify making changes to the documents. We did share this document with you yesterday, so I'm happy to go through it row by row if you like, or if anyone has questions, we can just address it that way. Daryl, which would you prefer? I think you're on mute, Daryl.
Yeah, I think we just go through if there's questions.
Okay. So the first one is really just to make sure that the checklist is consistent with the policy documents, which in particular with regard to the interaction of accrued time, employer provided paid time off with benefits. It is an area where there's different options. You can either substitute if it completely replaces the benefit, or supplement. And the recommendation is just to make sure that our language is consistent across the 3 documents, which we think makes sense. On the other hand, we did have a comment that says they were concerned with our language, which we said employers, we were citing the statute, the Connecticut FMLA, which says employers may permit or require an employee to use paid time off while they're taking Connecticut FMLA. And their concern was that it might allow employers to force the employees to receive their CTPL benefits simultaneously with the employer provided benefits when the employee may want to take them consecutively. And so the concern was, should we be allowing employers to do that? The answer is the statute, Connecticut FMLA statute, already allows employers to make that choice. And so our language in our policy filing guidance just reflected that statutory reality. So we really don't think we can make any changes to that because we can't supersede the statute. Next was about the length of time to allow insurers to pay claims. We said claims had to be paid within a maximum of 15 calendar days from the date the entity, the private plan carrier or employer, determined that the benefit should be approved. 15 days really is the outside limit. We're certainly not recommending that people wait 15 days, but we wanted to take into consideration that with intermittent and reduced schedule leaves, there may be some additional verification of hours that needs to happen. We wanted to take into consideration that there may be holidays, and we wanted to enable employers and insurers to establish a procedure where they're paying this benefits on the same day every week, just like we are. So again, we don't want to say that you have to wait 15 days. We wanted to have a reasonable time limit, and we wanted to make sure that there was some time limit so that carriers couldn't just wait and pay on a monthly or bi-monthly basis. So that's why we had the 15 days. So we were not inclined to revise this. Daryl, I see you have your hand raised.
Yeah, knowing that the payments are going to be electronic, ACH, or to somebody's banking financial institution, or potentially a debit card, I'd think, no paper checks. So the way the ACH process works, and we, in unemployment insurance, we discovered this a decade ago. There's a delay. And so my question is, for example, if you run the payment cycle on a Friday, potentially that file will go to the bank Monday morning, the financial institution that's doing your ACH on Monday morning, and it would settle into the customer's account on Tuesday. So, that's an example. And if you throw in a holiday, so I guess my question is, did you account for, the delay in the automation because it takes a couple days, sometimes longer, weekends and holidays?
Yes, that's part of the reason why we came to 15 days. But I just also want to note, for the authority, we are only going to do paper checks and stored value cards. But for private plans, we did not mandate that. So a private plan could issue paper checks. So, and that's another reason why the 15 days to get paid, may account for.
Oh, okay. I missed that. I didn't realize we're doing paper checks. So with paper checks,
we're not. We're not.
This is for private plans.
Oh,
these are the rules for the private plan.
Okay. All right. Thanks so much. I appreciate that.
Okay. Erin, yes, thank you. It's not a question, it's a comment. I also wanted to mention, Daryl, that while we got a lot of these comments from large employers and the Insurance Trade Association, we also have to keep in mind that a number of these private plans are with very small employers. So we really have to give them more flexibility to be able to do their work and to pay on time. And if we give them more time, it's a very new process for them. This gives them the cushion that they need in order to be able to do that. It also helps on the other side in the event that payments are not made on time and appeals are filed. This will really help to give more of a cushion for employers and employees to work through whatever challenges there might be with payment before something becomes an issue that becomes the subject of an appeal, which is why we're not inclined to change it.
Okay.
Part of it has to do with the perspective of the people making the comment, but we have an obligation to everybody who's in the private plan.
Understood. And, you know, I'm excited to see 15 days. Just for the conversation, unemployment for federal standards requires 21 payment by 21 days from the initial application. So this is really great to see. And it's a quick turnaround. So that's just my concern with all the dynamics. And this is kind of self-imposed. So, you know, let's see how this plays out. And it's great to read this and have this as a standard. Thank you.
Great. Thank you.
Thank you. The next comment was relating to how long we will allow employers or basically the private plan employer or their agent to require notice. We're saying that they can require advance notice for foreseeable claims and basically using the same federal FMLA definition of 30 days in advance for foreseeable leaves and as soon as practicable for leaves that are not foreseeable. And the question came in of, well, why would an insurer need advance notice? An employer needs advance notice for FMLA because they have to deal with the absence, but does an insurer really need that? Our answer was, one, we are trying to keep it as consistent as possible with FMLA to make it as simple as possible for everybody, employees as well as employers. We don't want to set timeframes that are different and then sort of send employees down the wrong path because they're using our timeframes and thus miss out on their job protection. But also, we think it's beneficial, even in the insurance side, to get advance notice so that all of the documentation issues get resolved before the person goes out on leave, if possible. So we still think that that is appropriate and is not an undue burden on employees or employers. Oops, I did not mean to jump to the end. All right, I feel like my document must be, I must be somehow filtered in a weird way because there are certainly more edits than the ones that just revised. Let me stop sharing so I can figure out what I did. Michael, if you have any thoughts on what I did and want to jump in.
I wasn't sure if it just, when you open the document, did it start 3/4 of the way down?
I don't know. Maybe.
I can share my document if you need.
Oh, no, you're right. That's exactly what happened. Sorry. Let me share again. Okay. That's the top. There we go. This is a good one to start with anyway. We got several requests to allow the employers to pay their regular wages to employees and then have the private plan reimburse the employers all or a portion of those wages. You'll see this comment in connection with the claims administration policy that we'll be addressing next month because people want the CTP leave program to do that. Massachusetts allows for this. At this authority, however, the staff does not believe that our statute allows for such a plan design, and it really turns an employee-funded program intended to benefit employees into a way to transfer those employee funds to the employers who really, if they want to provide their employees wages, probably have already accounted for it. And so we don't really see how it makes sense to have employee contributions used to sort of offset the employer's costs. And we don't believe our statute allows for it. So I think our expectation is that because the statute says the employers can pay concurrently with CTP leave benefits, and because CTFMLA says that the employer may permit or require an employee to use their accruals or other paid time, the expectation is that those still maintain separate tracks and that the contributions from employees either to the paid leave program, which we'll talk about next month, or to private plans should not be used to reimburse employers. Does anyone have any thoughts on this?
None from me, Aaron.
No, well, my only thought is, does the statute prohibit it, or does the statute not specifically address it?
The statute does not specifically address it, but the way we read the other elements, we don't believe that the statute was designed with that intent.
Okay.
Okay. There was a request to allow the self-insured plans more time to file their self-insured plan document. We do think that makes sense. I think the original date was December 10th, but we want to give them at least a full month. So, and we're not meeting with the board until next week. So we want to probably do the 10th or the 15th just to give people time. And just on that note, Michael's been working on a sample that is based on the elements that are set forth in the policy documents, but just as an example of what it might look like to, again, add, to make it a little bit easier for the smaller employers who might be doing self-insured plans to see what we're thinking about. Insurance companies obviously are very adept at filing plan forms, and larger, more sophisticated employers may be used to that as well, but we want to make sure that the smaller employers know what we expect with a self-insured plan document. Okay, I'll just keep going unless there are comments. One of the things that we're changing, because we're going into the live claims world, is the time frame between when the authority approves a plan and when it takes effect. During this past year, we have said that as long as the plan was approved on or before the last day of the quarter, the approval took effect for that quarter. So essentially it was a retroactive. We can't do that in the claims world. You can't approve a plan in in March and have it go back to January because you've got claims between January and March. But we are saying that they need to be approved at least 1 month before the end of the quarter. So in order for an employer to receive approval for Q1 of 2022, they need to have their private plan approved by December 1st. In order for their plan to be approved for Q2, they would need to be approved by March 1st. We originally were thinking about requiring a longer time frame, but that's really not workable. Question about how they report private. We anticipate that there may be private plans who have to, for one reason or other, transition into the CT paid leave program, either because the employer chooses not to continue at the end of their approval period, or they have to terminate at a sort of shorter point in time. We need to know how many weeks of benefits a private plan employee has used so that we can make sure that we don't have windfalls. And we want to know it in weeks because the entitlement is in weeks. And there is a question about how, if this is too difficult for a private plan to report the utilization of the benefit in weeks. And they wanted to just say, well, we can just report it in hours or days or weeks. The problem with that for us is that the entitlement is based on each employee's own individual work week, and it may not be a 40-hour work week. So in order for us to truly know how much time has been or how many benefits have been utilized, we need to know it in the framework of a week. But we recognize for people who have intermittent leave or reduced schedule leave, their entitlement may not be in a full week, in which case we expect the private plan transitioning to the public plan to tell us in a fraction of a week, which is how it's done in the federal regulations. So it's really not all that difficult for people to do, particularly if they're used to federal FMLA. Next question is an issue really, which is just sort of trying to work through the statutory obligations versus our plan. The Paid Leave Authority has an obligation to report to the legislature every July 1st on paid leave usage in the state of Connecticut. And we will need to report on sort of the private plan experience in that annual report. In order for us to get the private plan information in time to put it into our own report and make sure that the report is reviewed by the board and gets filed before July 1st, we were thinking April 1st would be an appropriate time. But this first year, people reporting on April 1st would only be able to report on basically 2 months of claim, so not even a full quarter. So we recommend changing the deadline for reporting to May 1st for this first year. And then starting in 2023, that go back to the April 1st and have the private plans report on the full calendar year. They've also asked us for more detail about what the reporting requirements will look like, with very specific details in a template, which is something we're working through, but we don't believe that is necessary to be put into this policy. That's not a traditional thing you would see in a regulation. We don't think it needs to be in our policy either. Okay. Paid leaves that extend beyond the date that a private plan terminates. So again, if it's possible that a private plan is going to terminate, they want to come into either the public plan or to a different private plan. And we're saying that the original carrier has to finish the claim before it transitions to the new carrier or to the public plan. And we want to make sure that our language is consistent. And so we have the language that we talk about with private insured plans kind of is very clear in terms of how the obligation transfers. Our self-insured document was not as clear, so we're going to make that change. There's also a comment that people were concerned about intermittent chronic conditions and wanting to make sure that an employer or insurer isn't sort of responsible for a claim going on for years and years and years because it's a chronic condition. We believe that that's really a misunderstanding of the way leaves work. And every leave terminates after 12 months and an applicant has to refile with a new claim. So there should never be a situation where a leave is approved for longer than 12 months, no matter how you calculate the 12-month period. So we don't think we need to make any changes with that regard. Andrea?
Thank you, Erin. I wanted to just go back a little bit to the date when the reports were due and wondered if we would consider it just leaving it at May 1, if there really is a reason to move it. I just think that April 1 falls right at the end of the quarter and it still leaves no buffer to collect and compile the data. And if it doesn't really matter to us, could we just leave it at May 1?
I think we certainly could. Our thought was that if we have April 1st, 2023 is going to be when they have to report on their 2022 usage. They actually have 3 months, but I think we can probably live with May 1st. And that may help with employers who are worried about trying to get their taxes in April and things like that.
That's what I was thinking as well. Yeah, to just give some breathing room. So that would be my recommendation, is just leave it at May 1.
Sure.
Okay.
Makes it easier to write too.
Yep.
Mike?
Erin, on the item you just mentioned about who's responsible, which plan is responsible for the claim where there's a transition. And I see your comment about every leave, there's a maximum of 12 months. Does that mean that the original carrier could be responsible for intermittent leave for up to 12 months after it's no longer the carrier, the official carrier?
Possibly. This is something that we have talked about with the insurance community, and the report back was that this is sort of consistent. If the claim for income replacement benefits in connection with a leave starts, say, the day before the plan switches from one carrier to another. The original carrier is sort of still the carrier on record and would carry it forward until the employee utilizes their full 12 weeks of benefits or the 12-month period ends. It's a pretty, we have to believe it's a pretty isolated occurrence to have someone sort of starts receiving benefits sort of right then, right before it transitions. But it could happen, so we want to plan for it. And this is the language that our communications with the insurers sort of they seem to want. They wanted to they wanted the original carrier to be responsible. They didn't want to have to turn over responsibility.
Yeah.
So the message really was just to keep it consistent with this, to make the self-insured plan consistent with the language the insureds want.
Okay, thanks.
Okay. The next one is really for everything, which is just making sure that our language is consistent, and that requirement of allowing the employee to hold on to 2 weeks of accrued leave is only applicable if the employee is also taking leave under Connecticut FMLA. As we've talked about, employees may be entitled to income replacement benefits even if they're not taking Connecticut FMLA leave. And so we don't want to import a restriction that's applies only to Connecticut FMLA to all types of leave. The next issue comes up with, we're no longer talking about when a plan terminates, but we're talking about when an employee of a private plan employer leaves that private plan employer for some other employment or to not be employed. The existing policy says that they have to hold on to, the private plan employer is responsible for covering that former employee for 12 weeks. But the issue was, well, if they become eligible for benefits for someone from another employer, they can't double dip. They have to pick one or the other. And so there was a question about how do we frame this? And do we say that if they become covered by another plan, does that mean that they are no longer sort of on the responsibility of the former employer? But saying that someone is covered under another plan doesn't necessarily mean that they're eligible under another plan. And so that's why we wanted to make sure that we don't create these gaps for employees who leave, because the statute definitely anticipated that former employees would have at least 12 weeks of accessibility to paid leave benefits. So we don't want to say that if you become covered under another plan, you're no longer eligible to receive benefits under your prior plan. And we're looking to see if we can clarify it instead to talk about if you become eligible under the new plan, that's when your protection under your old plan ends.
This comment raised, reading about it, thinking about it, raised a question. How will anybody know somebody left the Connecticut employer, went to work for a Massachusetts or New York employer? How will that get coordinated?
So for the paid leave program ourselves, the employee has to tell us who their employer is, and there's an employment verification form that we'll receive. And we with AFLAC, they'll be checking to make sure that the employee works for a covered employer. For private plan employers, it's a little bit easier for them because they're dealing with just their own employee population and not the entire population of the state of Connecticut. So they should have a closer, even if they have an insurer or a third-party administrator, they should have a closer relationship with their own HR to be able to say, you know, Erin Choquette worked here. I'm a private plan employer. I have this employee, Erin Choquette. Erin Choquette is left. we'll have to keep her on our plan for 12 weeks unless we get a report that she's covered. We do have in the language that if a former employee applies to their private plan for benefits, the private plan is entitled to ask that former employee, are you working for another employer right now, and are you eligible for benefits? So they'll be able to do the verification on a claims made process. Okay. Next one is what to do with an employee who has less than 2 calendar quarters of earnings. And for the state, we're saying we're using the base period because that's what the statute requires us to do. So if you have less than 2 calendar quarters of earnings, we're still going to divide by 26, which means your benefits will be lower because you're going to have a lot of zeros in those numbers. But private plans are entitled by statute to be more generous than the state plan. And so it is permissible for a private plan, if they want to do what the state does, which is divide the earnings by 26. Or if they want to be more generous, they could divide by the number of weeks that the employee has worked. They can't divide by the number of weeks the employee has worked if it's more than 26, but they can do it by less if they want to be more generous because the statute allows them to be more generous. All right, so next one was sort of an opposite of the 15 calendar days that we discussed earlier. This one was a request to give people essentially 30 calendar days to pay benefits. If the approval occurred before they take leave, and then they wanted to say, in that situation, the carrier would have an additional 15 days to pay the income replacement benefits. We don't think this is a well-taken suggestion. That seems far too long because you've already approved it. You already know when they're going to be out on leave, and you should have had everything in place to be able to start making benefit payments. So we don't think they need an additional 15 days. And again, it's not clear, it's not as apparent in this summary, but the context of this policy says the employer is aware that the employee is out on leave. As soon as the employee becomes aware and is needing the income replacement benefits, this kicks in. So we're not saying you have to pay right away if the employee hasn't reported that they're out. Another question again about income replacement, interaction with other income. And so there was a question about whether the way we phrased it was clear enough. So we're just going to make a change in all 3 documents to reflect that the reduction of benefits is only permissible in the event that it's necessary to avoid having the covered employee receive more than 100% of their earnings. Another question about when you can reduce or exclude based on other incomes. The comment was that we should say you can only reduce it if they're out for the same leave reason for the same period of time, but that's not what the statute says. So we don't think it's an appropriate restriction. As you know, we require the private plan employers to offer an internal review process, a request for reconsideration, essentially, as it's a voluntary measure to allow employees to resolve their disputes with their employer about the payment of benefits ahead of time, instead of having to go straight to DOL. This comment was just to make sure we use the word reconsideration instead of appeal when we're talking about that internal process. So we're going to make that change. Similarly, there was a question that says you do need to make sure that employees understand that they don't have to use the reconsideration process. They can go straight to DOL, and they should be advised of that right. And so we're going to add language to make sure that the denial letters are clear, that they have to report on the internal reconsideration process as well as information about the DOL appeals. There's a question that wanted us to provide more specific information in the policy about how to contact DOL. One, that's not really a great idea for policies because the contact methodology may change over time and we shouldn't have to go through the whole public process to change just a contact information. And two, we don't yet know exactly what that methodology is going to be. So we're definitely going to provide it. We're going to require employers to provide it, but we're not going to put the specific contact methodology into the policy document itself. Prior earnings. So this is actually interesting because it's an issue that came up last year when we adopted the policy, the original policy guidelines. We have said for private plan employers that they can look at only the wages that the employee earned while working for the private plan employer. The paid leave program looks at all wages, but we have access to DOL data to help us look at all wages. And we can't give DOL data to private plan employers. So we have said for a year now that it is permissible for private plan employers to look only at the specific earnings at that employment to determine eligibility and to determine benefits. We got a comment saying, well, if the employer wants to take on the additional sort of process of looking at prior employment and earnings from previous employers, they should be allowed to do so if they want to, recognizing that they're not going to get data from the state, but they could ask the employee for that data. And so that's something we're happy to recommend as an alternative if they choose to do so. Reconsideration prior to appeal, we've kind of addressed that. Employer contact. We wanted to make sure that the policy language includes the contact information within the, sorry, let me restate that. This is actually a request from DOL. This is to improve the appeal process. We need, as part of the appeal process, we're trying to create an electronic solution where once an appeal is filed, there can be sort of an automatic notification to an appropriate entity at the private plan saying, hey, you should know one of your employees filed an appeal. And so in order to do that, we need all private plan employers to notify us who should be their contact if an appeal comes in, whether it's the employer or a TPA or the like. And so we're going to add this requirement into the obligations that private plan employers, the information that private plan employers have to give the paid leave authority when they apply for their approvals, and just to maintain it on their accounts. So we're going to add that in. So this will simplify and streamline the appeal process because we'll know exactly who to send the appeal notice to. This next one is really specifically for the insured plans. And the idea here is the insurance companies are going to submit their policy forms to the insurance department. It's going to be a sort of a portmanteau document that is, this is our insurance form. There may be variations depending on the specific contracts, but this is the form. And we just want some version control. And so we're asking them to let us know if there's a version so that we know what form is included. Is that a fair description of this one, Michael?
Yeah, I mean, it's mostly when there's a change that happens kind of mid the 3-year period that they're in force. You know, we want to make sure if a claim came in prior to the date of that change, we're looking at the right version of the form. And if the claim came in after the date of the change, we're looking at the right version form for like audit purposes to make sure that we're using the right form at the right time.
Great, thank you. We have language in the documents that talk about when a change in the plan requires a new application and a new vote. And we have said that if there is a change in the law that requires a change in the policy, that does not obligate the employer to hold a new vote and submit a new application. However, we do want the insurer to tell an employer if they're changing their insurance policy because of a change in the law. So we think that obligation is important so that employers know what coverage they are getting. We also said that if there is a voluntary amendment, there should be a notice. And the carrier said, well, we don't initiate amendments. And we said, well, that's fine. If the employer requests the change, the insurance company doesn't have to tell the insurer, we're doing the change you requested. But if there's a change based on a change in the law, then the insurer must tell the employer that's happening. A couple just formatting issues. Question came in about whether or not employees need to use their accruals and whether that needs to be included in the plan documents. The insurer said, well, that's not our issue. That's an employer's issue. Why should we say that in our plan documents? And we said that we want the plan document to be useful to the employees, so they should know if the employer is going to require it. So carriers, you need to talk to your clients and find out if they're going to require it, and then you can put it in your plan documents. Okay. Accrued time that supplements benefits. Statutes allow it to be used to supplement leave or substitute. And we wanted to make sure that we address both situations. So we're going to make sure that the language is clear about when the leave is supplemented and when accrued time supplements a benefit versus when the accrued time substitutes the benefit. And so we'll make sure the language is clear about that. All right, and now we're back to where I started. So we're going to be making changes to a number of things, not all that many, but the goal is to make these changes and then bring this to the board next week to have them approve the changes, and then we can hit the races.
Great.
Any comments or questions?
Well, my only observation is many times when we post documents, we receive very few comments. So it's very impressive that we receive so many substantive comments, well thought out comments. So, and thank you for analyzing them for us and going through them.
Thank you for your time this morning. I know it's not the most exciting thing to do.
Thank you, Aaron. Thank you, Michael. Any other comments?
Daryl, I did want to, I'm sorry to interrupt. I really did want to thank the private insurer community because they really did spend an enormous amount of time reviewing the policy, the private plan policy documents, and they are primarily responsible for the substantive responses that you see. And we just think it's helpful for everyone that has a private plan that benefits from the time and effort that they put into it. So I wanted to just publicly thank them for their work.
That's great, Andrea. Yes, an amazing effort. Just going through the questions. It's quite a task. Again, thank you so much. Next on our agenda is old business.
I just have a old business question. We spoke at the last meeting. We were keeping an eye on the CBAC negotiations with the state, with the upcoming January 1 kind of deadline coming. And has there been any agreement yet between the state and CBAC, or are we still in negotiations?
There's been no report of any resolution between the state and the State Employees Bargaining Agent Coalition, known as CBAC, for sort of the larger all state employee negotiations that they're undertaking. We are still in communications with DISHR and the Office of Labor Relations about sort of the impact of the January 1st deadline on our existing employees. And so we have a good idea of what employees will be switched into classified state positions and what unions they'll be covered by based on their job titles. We're still working through kind of whether we just have to enter into a step to kind of just formalize things, or if it just sort of happens. But that's kind of on the granular scale. As far as the larger CBAC negotiations, those are still happening to my knowledge, but there's no real reports about what's happening with those.
Okay. And I just keep my eye on it because I think we said those negotiations will determine, I know we budgeted a certain amount of money for wage increases, but there could be other things that impact us effective January 1.
Yeah. I mean, the last big CBAC was 2017, and that was was voluminous in terms of the changes and impacts. So we'll just have to wait and see what happens. For example, in 2017, they changed the retirement benefits. So we'll have to wait and see what happens with this next one.
Okay, thanks.
Thank you, Mike. Any other old business?
No.
Okay. Moving to new business.
No.
All right. The last difficult item on the agenda is to adjourn. Motion to adjourn.
Move that we adjourn.
The second. Well, I'll second as chair. Any disagreements? All in favor?
Aye.
Aye. All right. Thank you, everyone.
Thank you.
Great update and have a wonderful week. Take care.